Are waivers in schools illegal? The answer is no. In fact, Article 6 of the new Civil Code provides that rights may be waived except when it is against the law, public order, public policy, morals, or good customs. Are waivers against public policy? The answer is also no. In fact, waivers in schools have been around since time immemorial. Now, for waivers to be valid, it must be executed by the parent or legal guardian on behalf of the student. And the waiver is also signed by the school head or any school official duly authorized to sign the waiver. Now, even if the waiver is valid, it is not always enforceable. To be enforceable, first, the parent or legal guardian must have been duly informed of all the inherent risks. In other words, if the circumstances of the scheduled activity are such that a reasonable parent would not have agreed to release the school from any liability had he known all the risks involved, and the school has not taken steps to inform the parents of such risks before asking them to sign the waiver, then the waiver is unenforceable. Second, for the waiver to be enforceable, the waiver should be clearly worded to release the school from any liability on certain damages, and the parents or students clearly agree. The parent or the student could not have agreed to a vague waiver. Finally, as a contract or agreement, the waiver is the law that governs the parties. Determining the validity of waivers is the function of courts, and therefore, only courts of law can invalidate or revoke a waiver that is validly executed. This has been Attorney Erap providing you with education principles as your education advocate.